This is Attorney Gehi, and we're going to start today's show, and we're going to talk about the visa bulletin. And before that, I think there's some issues with the connection, but I hope.
Now he's live. You're live now. You can start now.
Good to know that we are all live and we are good to go. So the number one thing, which is very important for all of us, this is Attorney Gehi, and we are going to talk about the visa bulletin. And before that, let me reiterate quite a few important points that we had during our last session. Number one is that we spoke about who can sponsor whom. So let's talk about American citizens. Whom can they sponsor? If you are an American citizen, you can sponsor your spouse, your fiance, your unmarried children under the age of 21, your married sons and daughters, your brothers and sisters, your children under the age of 21, and you can also sponsor your parents. So this is a big advantage of being a US citizen. So now there are some limitations when it comes to green card holders. Green card holders do not have the same facilities which are given to US citizens. So therefore, if you're a green card holder, you can sponsor your spouse, you can sponsor your children under the age of 21, and that is exactly a big benefit. And children over the age of 21 who are unmarried. So as you can see that if you're a green card holder, the easy way to look at the issue is to become an American citizen. But a citizen, on the other hand, has a lot more benefits than a green card holder. So let's talk about a few very important things today. Is that someone asked me that how long does it take if I sponsor my fiance? It's taking around 9 to 12 months for your fiance. On an average, it can be a little longer. For your spouse, around 12 to 14 months. If you're an American citizen, if you're a green card holder, it's taking 14 months. So parents, if you're a US citizen, that's all it is, and you can sponsor. It's taking around 14 months for your parents to come to America. I think that is fantastic. Brothers and sisters, things are getting better, but over a period of time, we're going to make sure that things should only get better with time, because I think the visa bulletin has started moving a bit. So today we are going to talk about family-based immigration, and next week we are going to devote a lot of time on the visa bulletin and the employment-based, processing periods. So today is family-based. So let's talk about the family-based categories and what's going on with each country at a time. So I have the bulletin for April. So in a sense, April has not even started, and I'm going to give you the news for April. So let's talk about family-sponsored immigrants and everything at this stage. So USCIS is accepting the filing, means if in the US, for the F1 category, which is unmarried sons and daughters of US citizens and who are over the age of 21. For that, you're looking at the filing dates are May 15th, 2016. So that's good. And the priority date is December 1st, 2014. So this is excellent. So for example, whoever had filed the petitions in 2016, so you're looking at 5 to 6 years for the children who are over 21. You're looking at the processing time at the beginning. So give or take in 2 years from the processing time, you're going to be good. Now, F2A, that is great news. You're a green card holder and you're sponsoring your children who are under the age of 21, or you sponsored your spouse. And your spouse can be a male or the female if your country recognizes it. That is current. So what does current mean under immigration law? If your spouse is currently visiting in the United States, if he or she is in legal status in America, she can apply for adjustment of status under Section 245A of the US Immigration and Nationality Act. So take an example, you're a green card holder. You met someone here and she is on a student visa, she's on a visitor visa, or she's on an H-1B. Do you know that if you marry her, you may be able to apply for a green card immediately? We've done this before, and this is food for thought for you. So if you're in an H-1B, even if you find a green card holder, there's no harm getting married. If you are a green card holder, you just got a green card, and your sweetheart is in a foreign country, well and dandy, come here, get married to her, come back, will be able to get up here in approximately 1 year. So that is fantastic news about the F2A category. Now F2B, which is also equally important now, what is going on in F2B is basically these are unmarried children who are over the age of 21 or green card holders. So over here, it's 2016 is going on. So if you're a green card holder and if you apply for a son or a daughter who's abroad, 2016 is going on in terms of the filing dates, and the priority date is 22nd September 2015. So in a sense, what I'm saying is 2016 for you to start working on a case. But if he's in America, on a student visa, if you're the father here, start applying for his adjustment of status. So next category is for married sons and daughters of US citizens. So for that, that's quite some time. You're looking at 22nd August 2009. So we have a wait to go around 12 years in that. And as far as the last category, brothers and sisters of US citizens, 2007 is going on. So folks, as you all can see, that these categories take time, but I think for people, who tell me it's taking a long time, I'm not going to apply for my brother and sister, I'm not going to apply for my parents, that's a big mistake they commit. Because there's a saying in life that time flies, and what happens with the passage of time, we realize that I wish I would have done it, and by now he would have been here. So keep that in mind when you're applying for your brothers, sisters, mother, father, start applying when the time is right. So that's my message to all of viewers. Now, if you're in America, even if you are not in legal status, you're out of status, but your parents over here, the green card holders, you're single, ask them to apply for you. Your brothers here, ask them to apply because you never know when the law is going to change. Your brothers here, he's applied for you. Your sisters here, ask them to apply for you. The bottom line is, start applying. Anytime you see a legal avenue, make use of it, because they're not going to tell you, the government is not going to tell you when the law is going to change. And if something happens, it's always going to help you that your case is pending. So take an example right now. I am in this country and I've overstayed my visa here. All right. My father is a green card holder. Ask him to apply for you. You're on legal status, ask him to apply for you. Your spouse crossed the border and she came in, she's married to a green card holder, ask him to apply for you. So the first step is very important. And what I've seen is that people just procrastinate it. They just kind of prolong things. That is something that can become a problem. So if I were you, start the application process. That's the best thing you could ever think about. So someone told me that, Mr. Gehi, my father is a green card holder. And I crossed the border and I came in over here. Should he apply? My answer is yes. Because when your priority date becomes current, you are eligible to apply for the provisional waiver, which was enacted by President Obama. So even through that, once if your waiver is granted, you may be eligible for a green card. So doesn't matter where you are. Like for example, we get calls from people from Ohio, we get calls from people from Alaska, from Hawaii, from everywhere. And our message is loud and clear to our viewers because we handle the cases. Some of them are not even in New York. We tell them one thing: there's no harm in applying. Applying for your green card through your relative can always be a benefit. It's something that is going to go a long way, and do it. Now, a few questions that came to me is, one of them was, Mr. Gehi, I had sponsored someone for a fiance visa, like someone who I love, and the fiance visa got denied. Now what should I do? Get in touch with the lawyer right away. And he needs to see why the fiance visa was denied, what really happened. And the second thing is, does your fiance have a chance of coming back? Sure. It depends upon the facts and circumstances of the case. If everything is well and dandy, if the officer just did not believe that the relationship was bona fide, and if your relationship is bona fide, and if there are no adverse factors, then definitely I think there is light, or there may be light at the end of the tunnel. So remember, folks, and in fiance visa cases, as I mentioned earlier, it's taking around 8 to 9 months. So if we have any questions, we'd ask basically our host to kind of turn on the questions so we can talk further on this. So I think right now we don't have a lot of questions. Okay, how do I know which EB category my employee is in? So if it's a skilled worker, it falls under EB3. And if it's a person that requires a degree, that falls under EB2. And if a person is of exceptional ability, it falls under EB1. So next week, we all are going to talk about the employment-based, immigration category. So stay tuned with us for next week, but that's going to be very important. Employment-based immigration and priority dates is next week's topic. Now let's take some other question. My employee has a priority date that was issued years before they started employment with us and before we started the green card process for them. Why is that? Because his former employer might have applied for it, and he can just basically, if the former employer is still interested in kind of employing him, he can still proceed with that case. Do NY and Gehi track the visa bulletin and priority dates? It's your duty to track exactly, the priority date and keep current. What are the two visa bulletins? There are two visa bulletins, especially because one mentions about the filing date and the second one mentions about the priority date. What is a 485 application? A 485 application applies to people who are in the United States, but when your relative or your employee is abroad, that process is known as visa processing. So under 245A of the Immigration and Nationality Act, if a person is physically present in the US, he can apply for adjustment of status. Can my employee downgrade from one EB category to another? Yes, he can downgrade it. And it depends on the reasons, but that is a possibility. How much does an I-140 cost? How much does a 485 cost? It all depends on the case. And those are confidential kind of factors, and you need to discuss with an attorney and figure that out. If my employee wishes to downgrade from EB to, can the I-140 matter be premium processed? All right, in order to downgrade, first go back to basically getting a labor done again. Then after that, let someone review your petition and then decide whether it's even worth kind of downgrading. Because what I've seen is people who downgrade finally wind up being in a bigger line. So sometimes it's better to be conservative than be where you are, but let a lawyer review the entire application, then let him decide. What is the cutoff date? Is exactly the date under which the visa can be cut off. Like this is the last date by which it can be finished up. That's a cutoff date. So folks, if there's any other questions, you can call us. And also, as you all rightly know, we have a book, Immigration for Everyone, and we have the recent version of it. It's on Amazon, and this is the second edition, which I have in front of me. The name of the book is Immigration for Everyone, and you can buy it on Amazon or go there. And it's a fantastic read for people who are outside the United States, who want to come to America, as well as for people who are in the US, who want to know about any category that they could think about. I've tried my level best to include as many categories as possible. So if you have any further questions, folks, we have 3 offices. We are located in New York, but we handle immigration cases from all over the United States and the world. The instant program is an attorney advertisement. Prior results do not guarantee future outcome. And our website is www.gehilaw.com. And we offer a free personal consultation. Our phone numbers are 718-263-5999 for our office in Jackson Heights, which handles cases from all over the US and the world. And we also have Zoom meetings with clients, so it makes life easy for everyone. Our Ozone Park office is 718-577-0711. Our office in Jamaica is 718-764-6911. And don't forget, our website is www.gehilaw.com. And yes, if you like the show, give us a great like. And don't forget to share this if you love this video. Thank you so much, folks. I'm very happy to see such a fabulous response from each one of you. And keep watching and spread the message when it comes to immigration. This is the show you can be on 1 p.m. Eastern Standard Time every week with Attorney Gehi until the clock doesn't change. Thank you, folks.